Welcome to the new manager and labor law training, where you will learn about employment labor laws, how it shows up in the workplace, and what strategic compliance looks like. Today, we're going to discuss your essential role as a compliance manager who can hire, train, promote, and discharge a team member. So let's begin. With today's schedule, you will learn about the agencies that govern California employment laws, the managers and employment law in the day-to-day workplace, and how we integrate the laws in the workplace, and how HR internal controls and HR internal controls for compliance. What you're going to need to learn as a compliance manager is what the organization's expectations are for the line manager pursuant to the topics and how to protect the company, the basic understanding of employment laws that could impact the employee personally, and what human resources expects the line manager to do and know with regards to these employment laws. So we need you to know your role as it relates to employment law and ensure the employees have equal opportunity to reach their full potential in the workplace. So let's begin with employment, the labor laws, and the agencies that govern those laws. In California, we have governing agencies that execute and enforce those regulations. Who are they? Who are the agencies? What are the goals of the agencies? And then we're going to take an deep dive into the statistics of what those agencies capture on an annual basis. So, who are the agencies? The California Civil Rights Department, formerly the Department of Fair Employment and Housing, is the state agency charged with enforcing California's civil rights law. The Equal Employment Opportunity Commission, also known as the EEOC, enforces federal disability discrimination laws. And the California DLSE is the state's Division of Labor Standards Enforcement. It is also known as the California Labor Commissioner's Office. It handles claims under the California wage and hour laws, as well as some whistleblower retaliation claims. The CCRA is focused solely on activities within California and enforcing the state-specific anti-discrimination laws. These often provide more comprehensive protections than the federal goal. What are the goals of the agencies? Well, education and outreach. A critical component of meeting agency mission is providing employers, businesses, and the public clear, accurate, and easily accessible information related to their rights and responsibilities under the laws that CCR enforces. To meet this need, the agency continues to develop educational materials and website content. They provide training and programs and engage in direct outreach to stakeholders. In fact, most of this material on compliance is coming from the agencies. So let's look at the DLSE goals. What are their goals? Well, they want to combat wage theft, protect workers from retaliation, and ensure that law-abiding employees are not taken disadvantage. And then make sure that workers are paid what they have earned. So why care? Why should employers care that employees are paid equitably? Well, beyond legal compliance, it's the right thing to do. There are also some practical reasons to commit to pay equity. I mean, you can brag about it. So a company's good reputation makes it easier to attract consumers and recruit and retain employees in today's competitive and informed workplace. The agency reports on their website if employers are open and transparent about pay practices, that we are more ready and we can accurately respond if any employees complain. So how are employers rating with compliance from these agencies? Let's take a look at the annual reporting. National origin and familial status. By reviewing the numbers, you can see where we as the employer want to focus on some of these. So let's look at complaints by category. Complaints filed by basis. This is what they call by category. We'll take a look at the different categories. We have age 40 and over, disability, discrimination and harassment, or disability-related accommodations, race, and sex and gender. These are the highest numbers that were captured in just 1 year. So let's look at the right to sue category. What is a right to sue? Okay, that's when the EEOC permits or allows an employee or a person who comes up with a charge to file an employment discrimination lawsuit in federal court. An investigation is not completed by the agency, and the person can go straight to court with a right to sue. The agency allows individuals, mainly if they have an attorney, to take their case straight to court. So here were some of the cases that fell under right to sue. Again, we have age and disability as coming up high. We have sexual harassment, hostile environment, and then we have sex and gender complaints. The agency had received 23,898 intake forms in 2020 from the members of the public who alleged civil rights violations. 13,708 of the claims were requests for an immediate right to sue in employment cases. Now that we can see that agencies are keeping track, let's review some of these laws. So we have the federal and state regulations. So now that we know that disability and illegal discrimination are among the highest reported, let's take a look at some of those laws that regulate behavior. So we have illegal discrimination and anti-harassment. So these fall under acts. We've listed a couple here, the ADA and the FEHA. So the FEHA is the Federal Employment Housing Act, which prohibits discrimination, harassment, or retaliation. Yes, that applies to the employers. So the ADA. Title I of the Americans with Disability Act prohibits private employers, state and local governments, employment agencies, and labor unions from discriminating against qualified individuals with disabilities in the job application procedures, hiring, firing, advancement, compensation, job training, and other terms and conditions and privileges of employment. As you can see, it encompasses many activities within the organization. So Title I also covers medical examinations, medical records, drug and alcohol abuse, and retaliation for opposing practices. So let's look at definitions of a disability. So an individual with a disability is a person who has physical or mental impairment that substantially limits one or more major life activities, has a record of such an impairment, or is regarded as having such an impairment. Well, the ADA was extended in 2009, creating what they call the Amendment to the Act. So the ADA defines disability in part as a physical or mental impairment that substantially limits a major life activity of an individual. This is the first prong of the definition. The amendment made significant changes to the definition of disability, making it easier for an individual seeking protection under the ADA to establish that they have a disability as defined within the law. By extending the terms of the ADA, the extension provides greater protections under the law. What they found is that the findings and purpose made it clear that Congress intended to apply a less demanding standard than that applied by the courts and to cover a broad range of individuals. So disability is not thought of as cancer or something significant. It, it's it is now something that we should focus on. So the law states, well, you got to be qualified. What does that mean to be qualified? Well, a qualified employee or applicant with a disability is an individual who, with or without reasonable accommodation, can perform the essential functions of the job in question. Reasonable accommodation may include. So, what the law is basically saying is if this individual can do all of the essential functions of the role, of the duties, then you need to help them by helping them with accommodations due to a disability that interacts with their ability to be successful. And some of the ways they want us to do that is making existing facilities used by employees readily accessible to and usable by persons with disabilities. Job restructuring, modifying work schedules, reassignment to a vacant position, acquiring or modifying equipment or devices, adjusting or modifying examinations, training materials, or policies. Reasonable accommodations are adjustments or modifications provided by the company to enable people with disabilities to enjoy equal employment opportunities. The accommodations will vary depending on the needs of the individual or applicant. Not all people with disabilities, or even all people with the same disability, will require the same accommodation. So let's take a look at the FEHA Act. The California's Fair Employment and Housing Act prohibits discrimination, harassment, or retaliation based on statutorily protected characteristics. So what are those protected categories? Well, California law protects individuals from illegal discrimination by employers based on the following. Okay, get ready because this is a long list. And so it starts with race, color, marital status, military, veteran status, ancestry, national origin, religion, creed, age 40 and up, disability, mental and physical, medical conditions, and genetic information, sex, gender, sexual orientation, gender identity, gender expression, disability, mental and physical. Not to worry, there is more. So what does it prohibit? Well, it is illegal for employees of 5 or more to discriminate against job applicants and employees because of that protected category or retaliate against them. So we just read you the list of the protected categories. So the FIA prohibits harassment based on a protected category against an employee, an applicant, and an unpaid intern or volunteer or a contractor. Harassment is prohibited in all workplaces, even those with fewer than 5 employees. This is just telling you what the Act covers. The agency recommends that employers understand what qualifies as a protected category under FIA. It is essential for an employer operating with the state of California. Well, now that we know there are protected categories, what it prohibits, it also covers the reasonable accommodation. The California Fair Employment and Housing Act requires employers to provide reasonable accommodation for individuals with a physical or mental disability to apply for jobs and to perform the essential functions of their jobs unless it would be an undue hardship. So reasonable accommodation can include, but is not limited to, the following: changing job titles, changing work schedules, relocating the work area, providing mechanical or electronic aids, or providing a medical leave. If you recall, the Act believes if you accommodate or calls for us to accommodate them, within limits, that they're able to perform the functions of the job. But that since each individual disability is different, we are expected by law to begin what we call an interactive process. So the interactive process, employers must initiate an interactive process when an applicant or employee requests a reasonable accommodation. We must also offer to initiate an interactive process when we become aware of the possible need for an accommodation. So in California, it is unlawful for an employer to fail to engage in a timely, good faith interactive process. The point of the process is to remove barriers that keep people from performing jobs they could do with some form of accommodation. The process requires an individualized assessment of both the job and the individual's specific physical or mental limitations that are directly related to the need for a reasonable accommodation. Many times those accommodations could just be having them to be retrained due to medication. There's so many different ways that we can help individuals on the interactive process that we actually have a form because to guide the managers to correctly identify the ways we can meet the employee's needs. But the best way is to just ask the employee, what do you believe are some ways that we can help you with these limitations? And I have found that many times it's the employees that come up with the best ideas. So let's move on. The equal employment laws. Well, we have the California Equal Pay Act and we have the Fair Labor Standards Act. California has our very own. So let's go into those equal opportunity laws or the acts. So let's start with the California Equal Pay Act. The California Equal Pay Act, also known as CEPA, forbids public and private employers from paying you less than what they pay employees of the opposite sex, a different race, or a different ethnicity for substantially similar work. So, substantially similar work. The definition is work that is mostly the same with regard to the following three factors. So it's almost the same except for these factors: skill, effort, responsibility. So protected activities. The act includes retaliation. Specifically, SEPA prohibits the employer from taking adverse action against an employee for either bringing a wage claim, revealing what you earn to another employee, asking about what the coworker earns, employees can ask, or talking about coworkers' wages. Yes, the act protects these type of discussions. So retaliation. So retaliation can take many forms. The act gives these examples: demotions, suspensions, terminations, reduction in hours, or reduction of wage rates. Reason why we brought up the this act was the claims are mainly based on the pay being different because of their gender or their race. And it's a pretty significant employment law that's unfortunately something that California is still working on resolving. So let's go into the Fair Labor Standard Act. So California Fair Labor Standard Act is a set of state laws that sets the rules for minimum wage, overtime pay, record keeping, and youth employment standards affecting employees in the private sector, federal, state, and local governments. So the FLSA prohibits employers from discriminating against workers based on their age, disability, race, color, religion, sex, or national origin. So once again, these agencies are enforcing these acts to ensure equal opportunity of wages is happening in the workplace. So that's the purpose of that. So this act actually has some exemptions. So under the FLSA, all employees must be classified as either exempt or non-exempt from minimum wage and overtime provisions. So the act is stating all of your employees must fall into a category, exempt or non-exempt. So one of the key aspects of the act is this provision for overtime pay. However, not all employees are eligible for overtime due to various exemptions outlined in the law. The single most common and costly mistake made by employers is the misclassification of employees as being exempt from the overtime provisions of the law. So what does that mean to a manager who wants to promote? Well, what it means is that standard regulates the roles, indicating that a salary test and a duty test must be given to the role in order to be exempt. And one of there are two things. They must earn a minimum monthly salary of no less than 2 times the state minimum wage for full-time employment. So that's 2 times the state minimum wage. And deductions from an exempt employee's salaries are limited and a weekly. So they have to be given the same amount on a weekly. And there are rules. To be considered an exempt, the person must spend at least 50% of their time performing exempt duties. So the state regulations are different from the feds. It's difficult to classify someone as exempt. Now that we learned some of the acts the agencies regulate, let's view how they show up in your day-to-day management. So how does it show up in the workplace? Where does it show up? How does it? Well, we just reviewed the acts and regulations that prohibit discriminatory practices. Well, how do they show up? They show up in the workplace through illegal discrimination, harassment, or retaliation. So discrimination in the workplace. Discrimination is defined as the unequal treatment of an employee or an applicant in any aspect of employment, based solely or in part of the employee's or applicant's protected characteristics, including their perceived protected characteristics. Earlier, we gave you a list of those characteristics. We're going to just add a few more. So, other categories: protected leaves, requesting, denial of leaves can be, this is what the agencies would call as a form of harassment or retaliation. So, protected leaves under FMLA or CIFRA, domestic violence, victim statuses, political affiliation. These are more protected categories. Sex, including pregnancy, childbirth, breastfeeding, or related medical conditions. And any other characteristics protected by state or federal anti-discrimination law covering employment. As you can see, it is pretty wide. Characteristics of discrimination. While discrimination may include, but not always limited to, what is it? Hostile or demeaning behavior towards applicants or employees because of their protected characteristics. Hostile or demeaning behavior. That's pretty broad. Allowing the applicants or employees' protected characteristics to be a factor in hiring, promotions, compensation, or other employment-related decisions. Withholding work-related assistance, cooperation, and or information to applicants or employees because of their protected characteristics. There's actually a list on the website of that includes many more characteristics of what discrimination looks like. And basically, what you need to be concerned about is if you're creating any obstacles or barriers for an individual to not move up, and is based on any of those protected categories, well, that's breaking the law. So this is something that you have to engage in on a daily basis and be aware of. It also shows up and harassment. Harassment is defined as unwelcome, disrespectful, or unprofessional conduct, including disrespectful or unprofessional conduct based on any other protected characteristics. Once again, this is written into the law. Harassment can be verbal, such as slurs, jokes, insults, epithets, gestures, or teasing. Visual, such as the posting or distribution of offensive posters, symbols, drawings, computer displays, or emails. Physical conduct, such as blocking someone's way or making physical conduct in an unwelcome manner. That goes into sexual harassment. Sexual harassment is defined as harassment based on sex. And we went over some of the categories, including pregnancy. It may include all of the actions described above as harassment, as well as other unwelcome based conduct, such as unwelcome or unsolicited sexual advances, requests for sexual favors, conversations regarding sexual activities, or other verbal or physical conduct of a sexual nature. So, sexually harassing conduct need not be of sexual nature or be motivated by a sexual desire. It may include situations that begin as reciprocal relationships, but later cease to be. So, sexual harassment is categorized into two types: the quid pro quo sexual harassment, this for that, or hostile work environment. As this is a required training that you've done, you're required every 2 years, we're not going to spend a lot of time on the definition. But I hope what you've captured is this is how the agencies view how it shows up in the workplace. And lastly, retaliation. Retaliation in the workplace. Retaliation is defined as any adverse employment action taken against an applicant or employee because that person is engaged in activity protected under this policy or reasonably thought to be protected under the policy. Protected activities may include, but are not limited to, reporting or assisting in the reporting suspected violations or assisting in reporting suspected violations of this policy and or cooperating in an investigation. So what's adverse employment action? Types of workplace discrimination. Employment discrimination occurs when an employer unlawfully treats members of a protected class differently than any other individual by refusing to hire them, failing to promote them, sexually harassing them, discharging them from employment, or unfairly denying them certain privileges or paying them less. You, as the manager, can defer this behavior by partnering with the in-house experts, human resources. I'll give you a definition of what adverse employment action is: conduct or an action that materially affects the terms and conditions of an applicant or employment or an employee's employment status, or is reasonably likely to deter the person from engaging in protected activity. Examples of retaliation. Examples of retaliation include, but are not limited to demotions, suspensions, reduction in pay, denial of a merit increase, or failure to hire or consider for hire, refusing to promote or consider for promotion because they reported a violation of the policy, harassing an employer for filing a complaint or denying promotion opportunities because they filed a complaint. Other examples include identifying harassment or other forms of discrimination in the workplace, treating people differently, such as denying an accommodation or not talking to an employee when otherwise required by job duties, or excluding the employee from job related activities because of engagement in activities protected under the law. So, as you can see, there again, it's pretty broad on the behaviors of what is considered retaliation. So if you learn that your role as a manager is the role that's going to ensure that every employee or applicant be given the same or equal opportunity to be their very best employee in our organization. But we understand you saw the acts, you seen how it shows up in the workplace, and it's a lot for a new manager to have to be responsible for. But I assure you, human resources is not too far from you. So we're going to talk about what strategic compliance looks like. Because we understand you're not here to play attorney or people or the friend. You are here to ensure the company's goals and objectives are met and your employees are engaged and developing to be their very best. So that's why it is a partnership. It is a partnership. Compliance is a partnership. So how do we comply? We comply with our HR processes and policies. We have created comprehensive anti-discrimination policies that outline the company's commitment to equal employment opportunities. They provide clear guidelines for addressing and resolving complaints. We have implemented ongoing training for all employees, including managers and supervisors, to ensure they understand their rights and responsibilities under FEHA and other anti-discrimination laws. So in order to ensure compliance with FEHA and to promote a discrimination-free workplace, let's take a look. So what are those internal controls? Well, there are policies. There are ADA, we have an ADA, accommodation policy, anti-discrimination, anti-harassment, California equal pay, the California paid sick leave, and our leave policies, FMLA, CFRA, regular sick, kin care, ADA leave, bereavement leave. These are just to name a few. We have the employment handbook that goes into a lot of these details. So you're going to find these internal controls and these policies in the employee handbook as well as the training. What are some of the HR resources? Well, we have the affirmative action statement, including our EEO hiring procedures. Every year we put together an affirmative action program, and that includes training, and you will be invited to that 1 hour training on what our program looks like and our goals. We just discussed the employee handbook and all required leaves. We have our performance development program and compensation policy with annual audits for compliance, and our policy on transfers and promotions. So most HR programs will have compliance embedded into the process, okay? For example, our promotions and transfers are tied into the affirmative action plan. So when you hire, select, and train, will include how to stay compliant within our affirmative action program. So training and compliance is our California anti-harassment supervisory training, and supervisors and managers go every 2 years, and they are required to go within 6 months of the date of your promotion, and then every 2 years thereafter. So we also have a training program on how to use performance improvement plans. So we did talk about employment separations earlier in the training. Well, prior to separating, we work very hard to improve the performance on our teammates. So we have a program that we can train you in helping your teammates get back to speed. We have our affirmative action program, our policy statement, and in that program, we will train you on to have how to identify and select replacements within the parameters of our equal employment laws. So you want to see the HR page for the full list of compliance trainings. So we are your partner. We are here to partner with you. So your role as a manager includes ensuring your employees have equal opportunity in all aspects of employment. That you access and learn more from the local agencies. So we provided a list for you that support equal opportunity by signing up to their websites. If you sign up, they as a subscriber, you will have access to really cool tools and resources that will help you stay current on the laws. So lastly, we need you to partner with HR for continued learning to be the very best manager. So thank you for attending and learning how to promote and grow your team through compliance.